Hello friends, how are you all? So let us continue international economic policy. This is the ninth video of this particular lesson. And in this lesson, we are going to study about one important agreement of the WTO, which is known as TRIPS. Okay, so the full form of TRIPS is trade related aspects of intellectual property rights. Okay, so the key word here is intellectual property rights. So this agreement is related to intellectual property rights and intellectual property rights which are related to the international trade, okay, which are related to exports and imports. So this is what we get from the the title of this agreement, TRIPS. Now first of all, let us understand what is the meaning of intellectual property. Many of you must already be knowing, but let me explain it to you in a very simple words. Intellectual property, the word itself suggests it is the property of somebody's intelligence. Okay, property of mind or wisdom or intelligence, you can call it anything, or scientific knowledge, okay, scientific or any other knowledge. So intellectual property is something, which is created by somebody's mind, intelligence, knowledge, wisdom, research, etc. Right? For example, if somebody has composed a very beautiful music, so that music is a property, intellectual property of the composer, of that person. If somebody has written a very beautiful poem, so that is a intellectual property of that person. If somebody has somebody invented the mobile phone, right, so that is the intellectual property of the inventor. So any scientific invention, any new technology, okay, anything that is developed, basically that is the intellectual property of the inventor or of the person who has actually created it. Now whenever international trade happens, see friends, whenever the international trade happens, that is exports and imports. For example, iPhones are exported, okay, wherever, for example, iPhones are manufactured, the assembly line is in China, but the product is of the America, okay, it is an American company, Apple. So America is actually exporting iPhones to the other countries. For example, it is exporting iPhones to India. So in India, we are using iPhones, we are paying a very huge price of iPhone, but it is an intellectual property of the the iPhone, the technology that is used, the designing and other features, everything is the intellectual property of the creator, of the Apple company. So and in the modern times, intellectual property holds very important position, because in the cost of manufacturing, in the total cost of manufacturing, if you see, if you look at only the components, the physical component of iPhones, maybe the cost is around 5,000 to 7,000 rupees. But you see the actual selling price of iPhone is 1 lakh rupees, 80,000 rupees, like that. So why is there such a difference between the actual physical cost of the physical component and the actual selling price? Because there is a huge premium involved here of the intellectual property of the Apple company, which keeps it as a premium. Okay, so whenever exports imports happen, it is very important that is intellectual property is protected. Otherwise what will happen, somebody will steal the idea, somebody will try to reverse engineer things, and then they will start manufacturing, they will start using that technology, and the benefit will not reach the actual inventor. So basically that is why this TRIPS agreement was included in the WTO original final act of WTO. And basically the developed countries, the countries which are advanced countries where scientific inventions happen, so they have tried to include this TRIPS agreement in the WTO. So now let us look at this. What is this TRIPS? So TRIPS, basically it establishes minimum standards for the regulation of intellectual property by the governments. See, now every country has regulations, okay, it has regulations, it has laws, it has rules, right, to protect the intellectual property in that country. But these rules and regulations and laws are different for different countries. So for example, maybe in India the rules and regulations are different, the meaning of intellectual property may be different in different countries, the interpretation of intellectual property may be different. Maybe in one country, maybe in India, we don't provide intellectual property to music, but intellectual property to music is provided to in America. Maybe I'm just giving you an example. So what is the meaning of intellectual property, what is the interpretation of the intellectual property, है ना, उसमें क्या क्या इंक्लूड होना चाहिए, व्हाट शुड बी इंक्लूडेड इन दैट, हाउ मच लेवल ऑफ प्रोटेक्शन शुड बी प्रोवाइडेड, सो दैट डिफर्स फ्रॉम वन country to the another. So this TRIPS agreement, it basically establishes a minimum standard that this should be the minimum standard of protection of intellectual property. That is what is said in the TRIPS, and it was part of the original WTO agreement, okay, of 1995. It was part of the original WTO agreement, so it is there since 1995. Now, intellectual property, there is usually a dispute or fight or arguments between the developed countries and the developing countries. See, because in developed countries there are more scientific, research, more knowledge, and they have the more they have more intellectual property coming up each and every day. Whereas in developing countries, the scientific research, the literacy rate is low, scientific research is low, R&D is low, and even in terms of innovativeness, creativeness, in developing countries it is low. So that is why intellectual property is a major concern for the developed countries. So developed countries want that their intellectual property be protected in the developing world also, because once they start trading with each other, once they start selling their products to each other, the developed countries fear that the developing countries will steal their ideas, will misuse their ideas, and maybe they will make some commercial use of that. So that is why there is always a argument between developed and developing countries that what should be the minimum standard of protection of the intellectual property. So basically, developed countries insist on a very narrow interpretation of TRIPS. Narrow interpretation meaning they want to have highest level of protection. Okay, narrow interpretation meaning they want to have the highest level of protection. That is what they ask for. So I'll just tell you one thing. You must have heard the word patent. Okay, patent. So patent means what? Patent is basically a legal right. It is basically a legal right of intellectual property. So patent is a kind of legal right of intellectual property. For example, somebody has invented the mobile phone, so that the person who has developed that technology of mobile phone, wireless communication, maybe that person may have patented that. Okay, he has patented that product or patented that technology, so that becomes an intellectual property of that person, and it is for a certain period of time, for some years, maybe for 15 years or 20 years or 25 years, like that, 50 years. So after that it becomes an open free technology for everybody, but for that particular period of time it is a intellectual property of that person or that organization which has developed that technology or that product. Now in the developed countries, so there are two types of patenting actually. So one patenting is known as product patenting, and another patenting is known as process patenting. Okay, I am telling you in a very simple words actually. So product patenting meaning that you patent or you obtain the intellectual property right for the product itself. For example, product is a mobile phone, okay, iPhone. So the intellectual property right is provided for the product, for the iPhone. Whereas in the process patenting, the intellectual property right is provided for the manufacturing process. Okay, the process through which you are manufacturing the iPhone. Now see, what is the difference between these two, product and process? For example, in America, in USA, iPhone is manufactured using a process, using a manufacturing process. For example, the manufacturing process is A, then B, then C, then D. Okay, so maybe by using this process, first A will happen, then B, then C. Using this manufacturing process, iPhones are manufactured in USA. Now, since there is a product patenting in USA, okay, if there is a product patenting in USA, iPhones are, patented. iPhones is the intellectual property. So nobody else can manufacture iPhone using even any other manufacturing process. For example, other manufacturing process is that first you do B, then C, then A, then D. Maybe this is also one of the processes through which you can manufacture iPhone. So if iPhone has got in America product patenting, other person, other organization, other company cannot manufacture iPhone even using the another manufacturing process, another process. Okay, but in India, for example, if there is only process patenting, okay, if there is only process patenting, that means India will provide the intellectual property rights or protection to this manufacturing process only, A, B, C, D. So in India, if there is process patenting, that means somebody in India can manufacture iPhone using another manufacturing process which is B, C, A, D. Okay, so protection is provided only to this manufacturing process and not to the product itself. Okay, so iPhone is not given protection, but this process is given protection. So somebody can manufacture the iPhone using another manufacturing process, which is, which may be BCAD. So in this way you can see that, there is a tussle between the developed countries and the developing countries because of this. Because in developed countries usually they go for the product patenting. They say that we will patent the product, no manufacturing process can manufacture our product. Whereas in developing world they go for the process patenting. There are reasons for it, I'll explain it to you why. Why developing countries want to go for process patenting. Now the Doha declaration, whenever when there was Doha declaration, Doha rounds of negotiations were happening, it initiated negotiation in this area because there was a tussle between developed and developing countries. So whenever there is a dispute, whenever there is arguments between two sides, we have to go for negotiations. So in the Doha rounds of negotiations, there was negotiations were initiated about the intellectual property, also about the TRIPS agreement, also as to what should be included, what should be the minimum standards. So that is there. So now let us see what does TRIPS entail. Okay, so TRIPS actually kya hai, what is there in the TRIPS, we'll now see that. So it requires the WTO members, meaning that countries which are signatory to the WTO agreement, to provide copyright rights. Okay, copyright rights meaning intellectual property rights, basically. Okay, protection to the authors. Okay, authors are meaning who are writing novels, books, etc. To the music performers, broadcasting organizations, geographical indications, GI, right? You must have heard about this GI tags. So GI tags are basically a product of a particular geographical region. Okay, so if some product has a geographical indication tag, so it means that that is the authentic product of that particular region. Okay, for example, Alfonso mangoes. So Alfonso mangoes, it is a GI tagged product. So basically it comes from a particular region of the state of Maharashtra. So if it has got a GI tag, it means that it is a authentic Alfonso mangoes. Okay, so GI tag is a kind of intellectual property only because it belongs to a particular area. It is an invention of particular area. Then industrial designs, patents, trademarks, etc. Okay, so it requires countries to provide these kind of protections. Then it also entails that the country should have enforcement procedures. For example, now you have given right, but there should be enforcement procedure also. If somebody is infringing upon somebody's rights, if somebody is trying to steal somebody's intellectual property right, so there should be some punishment given to that person. There should be some some kind of legal case that should take up. So there should be enforcement procedures. There should be remedies also, some kind of compensation for the original IPR holder, for somebody who is the true holder of that particular intellectual property right. So some remedy should be there for the redressal. Then dispute resolution should be there. If somebody is claiming that this is my IPR and somebody is claiming this is my IPR, so two persons are claiming the same IPR, then there should be a dispute resolution mechanism also. Some judicial or quasi-judicial mechanism which will decide as to whose IPR it is. Okay, whether IPR is involved or not, what is the interpretation of IPR, all those things. Now there should be a balance between the intellectual property right and the socio-economic welfare of poor people. Now see, this is where I wanted to discuss with you about why there is a dispute between developed countries and developing countries. So let us take an example that there is a medicine, there is a life-saving medicine, for a person suffering from malaria, for example. Okay, and this medicine was invented or developed in the country of USA. Now malaria is a disease which is there in the poor countries. For example, in Bangladesh, India, Sri Lanka, in the tropical countries, malaria is there, and these are the poor countries, these are the developing countries. Now these medicines are so costly because of the intellectual property right that a common person in India cannot afford these medicines. Okay, cannot afford, but it is a life-saving medicine, it is a life-saving drug. So it is necessary for the social and economic welfare of the poor people that these medicines be made available at a cheaper cost. Now if this medicine can be developed, can be manufactured by using some other manufacturing process at a cheaper cost in India or in some other developing country, then we will not think about the intellectual property, because it is for the poor people, it is for the social economic welfare of the poor people, for saving somebody's life. Okay, so that is why in developing country usually they go for the process patenting and a broad interpretation of TRIPS. So they ask that that whenever the question of the social economic welfare of poor people comes, we will not get involved into IPR, because they feel that IPR is a kind of first world problem. Okay, we are facing very basic problems of the poor people and we cannot think about intellectual property. If some intellectual property is useful for the poor people, we are going to use it. Okay, we have to use it for everybody and not just for somebody who has invented it. Okay, so this is just an example, there can be other examples also like this. So we have to balance between the IPR, intellectual property protection, and the socio-economic welfare of poor people. That is very important point of TRIPS, and this is where actually the negotiations are happening about the TRIPS. This is where the main contention is there of the poor country and the developed countries. This is where the main fight is there actually. Now let us look at the next agreement, which is a trade related investment measures. Okay, trade related investment measures, TRIMS. It is known as TRIMS, trade related investment measures. Now investment measures meaning it is a kind of policy of the government of any country related to the investments in that country. Investments meaning investment for business purpose. For example, if a company in America, a company in America wants to invest in India, it is a kind of FDI. Now there will be certain rules and laws and policies of the Indian government which they have to follow. So that is known as investment measures. So it is not strictly the FDI policy, it is not the investment policy, but it is investment measure, meaning it is a small requirement that particular company or that particular any manufacturer should fulfill. And whenever these investment measures are affecting the international trade, the exports and imports, they are known as trade related investment measures. We will look at the example what are that. So basically the first point that this TRIMS agreement does is that it acknowledges that investment measures can control and twist trade. Okay, so the small regulations and rules and requirements of this country which are related to the investment, it can affect the international trade. Okay, first thing is that it acknowledges it. Okay, it accepts the fact that this can affect international trade. Then TRIMS requires, okay, now what does the TRIMS agreement require? TRIMS requires that the member countries of WTO will not bring any investment measures. Okay, it is prohibited. It will not bring any investment measure, meaning any such rule or requirement that will differentiate or lead to quantitative restriction on trade. So a country, maybe it is not directly imposing any trade barriers. Okay, so trade barriers directly it is not there, but because of these investment measures, these kind of barriers are getting created indirectly. So this is a kind of indirect barriers to trade. Okay, indirect barriers. And it may lead to differential treatment of different countries, or differential treatment of domestic goods versus foreign goods. And it can also lead to quantitative restriction also. We'll look at the example how does it lead to all that, but I'm just telling you that investment measures that will lead to this kind of differentiation and quantitative restriction on trade, that is prohibited, it is not allowed. And it was also a part of the original WTO agreement of 1995. Okay, it was a part of the original agreement, that also we should note. And it only applies to investment measures related to goods trade and not services. Okay, so service trade is not yet involved in TRIMS. It is only related to the goods trades. It doesn't regulate foreign investment. Okay, it is not a FDI policy, but it is TRIMS just says that we should not bring any investment measure that will that will twist the international trade, that will lead to any distortion in the free trade. It's about discriminatory treatment of imported exported product versus the domestic product. Let us look at the examples. What is the meaning of that? So the first thing is TRIMS has restricted the following. Okay, it has restricted the following things. First one is the local content requirement, LCR. Now what is LCR? Example is Apple wants to sell products in India. Okay, so basically USA wants to export iPhones in India, but India agrees only if it uses batteries made in India. Okay, so India will say that you can sell iPhones in India only if you use the batteries made in India, battery in the iPhone made in India. So that is a requirement. If India says, then it is actually leading to a restriction on trade. Okay, so this is not allowed basically. Then next one is a trade balancing requirement. Okay, so there is if if a country has a trade balancing requirement, that is also prohibited. Now example of that is, see, for example, there is an Indian company that exports desi ghee to foreign. Okay, for example, there is a company ABC corporation, and this ABC corporation is selling desi ghee in America. Okay, desi ghee in America, in USA it is exporting from India. Now this ABC corporation wants to expand its business, and now it wants to import cheese and sell in India. Okay, now it is selling desi ghee in USA. It wants to now import cheese, okay, from America or any other country, and it wants to sell in India. Now the Indian government gave them the condition that they can only import as much cheese in value as they can export ghee. For example, Indian government will tell them that, okay, if you sell 10 lakh rupees of ghee, then you can import only 10 lakh rupees of cheese. Okay, so you have to balance the trade. If 10 lakh ghee is exporting, then you can import only 10 lakh rupees of cheese. So this is known as a trade balancing requirement, and this kind of thing is prohibited. This kind of thing is not allowed as per the TRIMS agreement. So a country cannot do this. The next one is foreign exchange restrictions. Okay, limiting imports by limiting access to foreign exchange. So a country's monetary authority cannot put any restriction on access to foreign exchange. For example, if somebody in India wants to import sugar, if it wants to import sugar, so a country cannot say that we will only allow you to import sugar up to $10,000. Okay, $10,000, that is. So a country cannot do that. So there has to be a liberalized, completely 100% liberalized current account. Okay, current account should be completely liberalized, and it is already there in India. Okay, current, we have seen in balance of payment there are two accounts, current account and capital account. So current account has to be 100% free, so that is there. And domestic sales requirement, example, restricting exports and forcing domestic sales of products. For example, if Apple is manufacturing iPhones in India, so if India says that you can only sell it in India, you cannot sell it outside, because the price of iPhone, because you are selling in the other countries, it is going above 1 lakh. So this extra demand is getting created from the rest of the world, and because of this extra demand, the prices are going up. But we want to we want you to sell products only in India, so that the prices are less. Okay, the prices are low. So also this is also not allowed. So in this particular video, we have studied about the TRIPS agreement and the TRIMS agreement, where two very important agreements of WTO. Okay, I hope you have understood. If you have any issues, any questions, you can ask me in the comment section. Thank you.